everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, your trusted source for immigration updates, expert legal insights, and real time conversations with experienced attorneys. My name is Anasia Mukherjee, and I'll be your host for today's important session I-751 Petitions to Remove Conditions on Green Cards, How to Handle Joint and Waiver Filings. For many immigrants, obtaining a green card through marriage is an important step towards building a secure future in the United States. But when that green card is conditional, the process of filling up the form I-751 can feel complicated, stressful, and full of uncertainty. Questions may often arise. Should you file jointly with your spouse? What if you're separated, divorced, or facing hardship? Can you still qualify through a waiver? And how do you avoid mistakes that could jeopardize your status? That's why we're here today to provide clear answers and practical insights that help conditional residents move forward with confidence. By the end of this webinar, you will gain a step by step understanding of the I-751 process, learn how USCIS evaluates petitions, and get tips to avoid delays or denials. We're honored today to be joined by attorney Josette Domokos, a dedicated immigration attorney and the founder of Palo Alto Immigration. Driven by her belief that America is truly a nation of immigrants, attorney Domokos helps individuals, families, and businesses navigate complex immigration processes with clarity and compassion. She is licensed in California and Colorado, a proud member of AILA, and a volunteer at Oasis LGBTQIA+ Asylum Legal Services. With expertise in family-based immigration, waivers, naturalization, and humanitarian relief, she brings both technical knowledge and a human-centered approach to her practice. You're welcome, Attorney Domokos. We're thrilled to have you today.
It's a pleasure to be here. Thank you.
Before we dive in, a quick but important reminder, immigrationquestion.com is a two-in-one platform that connects users with licensed immigration attorneys. We are not a law firm, and we are not affiliated with AILA or USCIS. All legal services provided independently by our attorneys in our network. So let's get started. To begin, can you explain what an I-751 petition is and why conditional residents are required to file it?
Yeah, absolutely. So if you are married to a U.S. citizen or permanent resident and you obtain your green card through that marriage, but that marriage is less than 2 years old when your green card is granted, you'll have a conditional permanent residency as opposed to the 10-year green card, which is the other option. USCIS really does this to kind of weed out fraud. And so what they're doing is 2 years after the initial green card is granted, when it's conditional, is that they have you essentially prove again that this is a legitimate marriage.
All right, thank you for that. What are the main differences between filing jointly with a spouse and filing for a waiver? And how does USCIS review each type of petition?
Yeah, that's a great question because there are those two main ways of filing. Jointly is if you are still married and both spouses are going to fully participate and sign the form, then it's a joint filing. A waiver can fall under 4 different categories. The 2 primary ones are if you are divorced at the time to file for the 751, or if you've been in an abusive relationship and your spouse won't or cannot, appropriately cooperate with you. There's also extreme hardship and death of a spouse. Those are the 4 ways, but really the primary ways that you'll see the waiver being filed are in the divorce and the abusive situations. If you're filing together, that's the ideal situation where you both can collect the information that you've had over the previous 2 years, and that is essentially what you're doing. Whatever you put in for the I-130, the financial shared information, the shared life, the photos, the affidavits, the messages, things like that. You'll have collected those ideally, over those 2 years, and then you'll be ready to file with that evidence together, and you'll both sign, and then that case moves forward as a joint filing. For a waiver, if you are divorced, you will need that divorce decree. in order to file that as a waiver. And essentially there, what you need to show is not that, your marriage was perfect. It's just that it's not viable anymore, but it was a legitimate marriage at its inception. It wasn't entered into for immigration purposes. So for that one, you'll need kind of the same evidence up until the time that you separated. So obviously, if you were married for, say, 18 months and then you separated, or you'll need that divorce decree to do the waiver filing. You should still file, even if you don't have the divorce decree, which we'll get to in a little bit about the timing of filing. But if it's an abuse case, then you'll want to file again with evidence of the marriage that you did live together, that you did have a shared life, and that was the intent, and it didn't work out due to the abuse of the spouse. So having medical records, having police records, your own statement would be valuable, affidavit letters from friends and family that know about the situation. All of that is important in that kind of filing.
Thank you. For someone facing divorce, separation, or hardship, what evidence is most important to strengthen a waiver application?
So with the waiver application, showing that at its inception, this was a legitimate marriage, that this bona fide evidence that you submitted when you filed your I-130, you can still submit information from the time you got your green card until the time that you separated or that the marriage was no longer viable. So whether that is, hopefully it's more than 2 weeks, but if it were 2 weeks, that's what it is. If it's many months, if it's almost the full 2 years, you'll want as much information that you live together. That's a critical piece, the living together. As well as sharing financials is important. Filing taxes together, having joint bank accounts, joint health insurance, holding a joint car title, for instance, or other larger purchase. Those are all really important things. Showing that you shared a life together. So if you have any children born of the marriage, their birth certificates. Also showing that you took trips together through photos or, reservations, online reservations, Airbnb reservations, anything of that nature. And then you can also use affidavit letters like you may have with the I-130 when you originally applied for your green card. You can have friends and family write letters as to why they still believe that this is or was a viable marriage at its inception and wasn't entered into for immigration purposes.
Thank you. Many applicants worry about making small mistakes that could lead to delays or denials. From your experience, what are the most common errors and how can people avoid them?
I'd say by and large, the biggest error is the timing. It's really important to get this timing right of the filing. So there's a 90-day window before that 2-year green card expires, and that is the window in which you must file. Some people file too late. They miss that window and they realize, oh no, my green card is expired. Still file, even if you realize your green card is expired, and write a statement as to what happened. Give an explanation as to why this filing is late. Equally as bad is filing too early. Even if you file, 100 days instead of 90 days ahead of time, it could take months for USCIS to reject that filing, and you might find yourself with a very narrow window in which to file once you see that that application has been rejected. Another issue is ignoring RFEs. RFEs, which are requests for evidence when USCIS wants additional evidence on your filing, they can be scary. It can be overwhelming. Often they're 4 and 5 pages long, and they are just overwhelming to read. But it's really important when responding to an RFE to, number one, respond to it on time. You generally have about a month, so get to work on it right away because that month goes fast. And often they're asking for additional evidence about the marriage. That's probably the most common one. And so you'll want to go through each request on that RFE and make sure that you respond to it, because not responding to one component can get that whole application denied. Another thing another area where there's a mistake is sending in an incorrect filing fee or not signing the application. So USCIS will not accept computer-generated signatures. They want to see a wet signature or a scan of a wet signature. That's penned actual paper type of signature on those forms. And then check the filing fees online at the USCIS website before you send it in. That's the best way to ensure that you're getting that correct. So generally, those are the biggest errors that I see. Don't be afraid to tackle, right on the time that you need to respond to those RFEs. Use the USCIS website to look up those filing fees and make sure that they're correct when they're going in.
Thank you. How do you advise clients to prepare their supporting documents and organize their evidence so that it clearly shows eligibility?
Yeah, this is a really important step to do, because if you just jumble your papers together, the harder it is for the USCIS immigration officer to go through it. The more frustrated they might be, the less clear your eligibility is. So it is important to have some sort of table of contents, and then frame it so that you're working with, for instance, financial information all together. Put those taxes together along with, the health insurance that you've paid for, with your bank account statements, that sort of thing. Put those in one group. Put your personal information together. So the family photos, the reservations, the text messages, and then affidavit letters, at the end. Those are very good to use, but they don't carry as much weight as, say, for instance, a lease or a mortgage would. So you kind of want to also stack them in the order of importance, meaning the financial information carries a lot of weight with USCIS, and living together carries significant weight with USCIS. So those are the documents that you want up front. And then you want to put your personal information, your family life together, and at the end, the photos and affidavits. And then make a table of contents. It doesn't need to be complicated. It doesn't need to list every last little item, but at least give a roadmap to USCIS, so that way they see, okay, this is what's in here. This is what I can expect. In the end, it's a person reading this over, and the easier you make it for them to read it over, the more beneficial it is for you.
Definitely. To everyone joining us from Facebook, YouTube, and LinkedIn, thank you for being here. Whether you're a legal professional, community advocate, or someone just looking to understand this better, we're grateful to have you. And if this is your first time with us, welcome. We are immigrationquestion.com, a meeting ground between immigration attorneys and individuals seeking immigration questions. Our two-in-one platform is built with outstanding features to help simplify the immigration process. Though we are not affiliated with AILA, we are trusted by many AILA attorneys who use our platform. With immigrationquestion.com, you can also ask your immigration questions for free in any language and get connected with a licensed attorney for legal guidance. And yes, just like many of our users, you may also receive a free confidential initial consultation. Just visit www.immigrationquestion.com to learn more. And it gets better. We've just launched our new mobile app designed to make access even easier, whether you're a user or an attorney. We have amazing news. ImmigrationQuestion.com is now BBB accredited. We're proud to announce that ImmigrationQuestion.com has earned Better Business Bureau accreditation. We now bear a mark of trust built by BBB standards, honest advertising, transparency, honoring promises, and handling consumer concerns the right way. The recognition shows our ongoing commitment to serve you with integrity. Attorney Domokos, as a respected immigration attorney with your extensive experience with family based immigration, naturalization, waivers, and many other aspects of immigration, how would you describe the impact ImmigrationQuestion.com is having on the immigrant community and on immigration attorneys like yourself?
Well, I think it's very valuable for people who have questions to be able to come to a trusted source, a source where they know they're not going to be scammed, that their attorneys are really attorneys. They're not, someone who is acting as an attorney who may have or may not have accurate information for them. Building community, I feel, is really important. It's a daunting process, virtually all of the types of applications. And so just knowing that you have a community behind you can just lend so much support to how you feel and just make the process that much more smoother.
Thank you for that. It is gratifying to know that both attorneys and immigrants benefit immensely from our platform. Before we dive into the Q&A session, what practical advice would you give someone preparing to file their I-751 for the first time so they feel confident in their petition?
Hmm. No, first off, the expectation is that it's going to be a long process, right? Currently, it's somewhere between 2 and 4 years, the processing times, which I know is a huge range, but it really is that. When you file, you'll get a receipt notice. That receipt notice is gold. You need that receipt notice along with your expired green card to work, to travel, pretty much to do everything for the next up to 4 years. So knowing that it's going to take a long time, and it doesn't mean there's something wrong with your application. That is, I think, really important because the worry is really difficult for people. And knowing that you're in the same boat as so many other people waiting for this process, and it's not anything that you've done wrong, and your application could be, a stellar application. It's just that the processing times are really long. So check online periodically, and don't feel that it's taking a long time. I've done something wrong. It's going to be denied, because chances are that you've put together a good packet as long as you've done your research, consulted with an attorney, and it will eventually be adjudicated.
We're now moving on to our live Q&A session. So if you've got a question for Attorney Domokos, now's your moment. Drop your questions in the chat or call us live at 516-703-3483. All right, our first question is, my US citizen spouse and I are separated but not divorced yet. Can I still file a joint I-751, or do I have to wait until the divorce is final?
I would go ahead and file during that 90-day window. You must file during that 90-day window. If you file jointly because your divorce is not final or you're separated and you're not sure which direction the marriage is going, then you'll need to convert that over to a waiver case if the divorce becomes final. Really, it's fine to file jointly because nobody can know the future for sure. There could be reconciliation. In many instances there are, in which case you continue with that joint filing. However, once you have a divorce decree, absolutely contact USCIS and convert that over to a waiver.
Thank you. Next question is, my husband passed away before we could file the I-751 together. Do I qualify for a waiver, and what kind of documents should I include?
Yeah, well, first, I'm really sorry to hear that news, and I wish you well. If your spouse has deceased, then what you'll need is the death certificate, and then the same information that you would file with any sort of waiver or jointly, which is proof of a bona fide marriage. So you'll want to show that you did live together. You'll want to show that you had shared finances. If you had children together, you'll want to include their birth certificates. Any sort of have some photos together, have some affidavit letters from friends and family. If you had health insurance, life insurance, car insurance together, any sort of shared credit cards, bank accounts, you'll want to include as much of that information as you possibly can.
All right, next question is, what happens if my conditional green card expires before I get a receipt notice for my I-751? Will I be undocumented during that time?
So you're not undocumented, thankfully. You are in what's called a period of authorized stay. So you're not going to be able to show that you have, authorization to work or authorization to travel until you have that receipt notice, because your green card is expired. An expired green card just means that you don't have the proof to show that you're a permanent resident. It doesn't mean that you're not a permanent resident. You are still a permanent resident until a judge takes away that permanent residency. So you're not undocumented. It just means that you filed, very close to the expiration date of your green card. The main thing is just to be sure that you are not starting a new job in which you need to show work authorization, or traveling because you'll have difficulty being readmitted to the country. So hang tight. wait for that receipt notice, and once you have it, all will be well.
Thank you. Next question is, I came to the US very young and got married quickly. Now I'm divorced. I don't have much financial history with my ex. Will affidavits from friends be enough?
So affidavits from friends alone probably will not be enough, but there is other evidence that you can show. So if you have some financial commingling, go ahead and put that in. So if you've filed taxes jointly, even once, perfect. If you were an authorized user on a credit card, that's also helpful. Showing mail that you received at the same address that has both of your names on it is good as well. You can even go back a little bit further than before you got your green card and show some parts of the wedding, showing that, this was a real relationship. It just isn't viable any longer. I would definitely get affidavit letters. Those are important. Be sure the affidavit letter writers include a photo ID and that they declare, under penalty of perjury, that what they're writing is true and accurate. As much information as you can provide to USCIS will make your case stronger and more likely to be approved. So really look back through your emails, through your text messages, find all of the things that show that this was, a real and legitimate marriage. But definitely include more than just the affidavit letters.
Definitely. Thank you for that. Next question is, I missed the 90-day filing window for my I-751 because I didn't know the deadline. Will USCIS deny my case automatically?
No, and I absolutely encourage you to file, even if it's a few months late, definitely file. You will, that is one of the ways you can end up losing your permanent residency is if you've never filed to have the conditions removed. So have them file late. It's better than not filing at all. Write a statement as to what happened, even if it's, it's an honest mistake that you weren't paying attention to the deadline. Maybe you weren't aware because you filed on your own and nobody had ever informed you that you needed to remove the conditions. Write a truthful, brief statement to USCIS. It won't be an automatic denial. Obviously, the more persuasive your excuse is, the less likely it is to be denied for being late. But chances are that, especially if you build a strong package otherwise and it's just late, that it will still be adjudicated.
Thank you. And our last question is, I submitted my I-751 on time, but the biometrics appointment was scheduled for when I'll be traveling abroad. Will missing it cause a denial?
So definitely reschedule that biometrics appointment, preferably before the biometrics appointment occurs. If it's already passed, definitely call in and reschedule anyway, and state that you were traveling abroad, you were out of the country. That is a reasonable excuse for missing a biometrics appointment. Rescheduling one time usually is not too much of an issue, but stay on top of it. Don't let it get away from you. Address it head on as soon as you can. And that's the way to make sure that it does get rescheduled in a timely fashion. You'll attend your biometrics, and chances are that the application will just proceed as usual.
Thank you, Attorney Domokos, for walking us through those critical insights. This guidance is especially valuable for anyone approaching their I-751 filing deadline or worried about their status. To our audience, thank you again for joining us. We hope this conversation has given you clarity on defending against deportation and the effective legal strategies applicable for today's immigration courts. Don't forget, at immigrationquestion.com, you can ask your immigration questions for free and get in touch with a licensed attorney who understands your case. You may also be eligible for a free confidential initial consultation. So head over to www.immigrationquestion.com and sign up today. And if you want to revisit this session or share it with a colleague, you can catch the replay on Spotify. Just search Borderless Talk by immigrationquestion.com. Join us again on Friday for another enlightening conversation. You won't want to miss it. Once again, thank you so much, Attorney Domokos. We can't wait to have you back again.
It's been my pleasure. Thank you so much.